Are we ready to proceed again with Mr. Vogel? Cross-examination?
Yes, I am. This is Chris Pierce-Wright.
Okay, go ahead, Mr. Pierce-Wright.
Should we swear the witness in again?
Oh,
He's already sworn in.
Okay.
I think, no, he's already sworn in, so I take it that he's sworn in for this continuation. Go ahead.
Claudia, did you have something you wanted to?
oh, we can wait. I just have dates for the next hearing, but we can wait till this is finished.
I thought we'd wait till we can free up Mr. Vogel
Okay.
and then deal with that, but thanks. Go ahead.
Good morning, Mr. Vogel. Chris Pierce-Wright for the Port of Olympia. I appreciate you being here again this morning. I want to ask you a few questions, and I would like to start with your background, specifically as it relates to review of airport master plans and the Federal Aviation Administration. Do you have any expertise in the process of FAA review of airport master plans?
I guess I wouldn't say I have expertise in FAA master plans. I have reviewed and participated in what I would call programmatic plans most of my career. And, one of the first things I do when I am doing that is I go back to the guiding statutes, So I am familiar that the FAA has advisory circular 150/5076B, which among other things in 504C, it says the potential environmental impacts of the proposed airport development alternatives should be addressed in a candid manner and written so that the public easily understands them. And it also goes on to give guidance about the level of detail at the master plan level for addressing sensitive environmental impacts. I can go in more detail, but I am familiar with that, yes.
Sure, I appreciate that. And were you reading off of something that's on your screen?
Yeah, it was reading off of the FAA's advisory circular.
Sure, perfect. And Mr. Examiner, I guess I'd ask that, and this happened a few times yesterday, that witnesses not read things that are separate from what's being introduced in the hearing from their own screen.
I don't see any problem with them doing that. I don't know why that's a problem. What's the objection to that?
Well, let's do this. If the witness, if the answer includes reading from a document, that the witness should say, I'm answering with reference to a certain document.
Yes, sir. Sorry about that.
Would that work?
And I'd like to note that is an exhibit in the record, Mr. Examiner.
Yeah, that may very well be, but let's do it that way. I think then we can proceed.
Yeah.
Great. So you reviewed that advisory circular for preparation of your testimony today and yesterday. Is that accurate?
Yes, for the FAA, that is accurate. Yes.
Had you reviewed that advisory circular before preparing for your testimony?
No, I reviewed that this morning as I was considering the sort of the disconnect between other guidance I had seen in the past, and I was wondering if the FAA had similar guidance about how to handle the programmatic level of planning.
Right. And I guess just to make sure I understand your history, before preparing for this proceeding, you had not previously reviewed the FAA advisory circular.
That is correct.
Okay. Do you have any expertise or background in the required FAA approval for constituent parts of an airport master plan?
No.
Are you familiar with the requirements related to FAA approval of an aviation forecast?
No.
How about an airport layout plan?
Nope.
Have you previously participated in or have expertise in the alternatives analysis process that leads to an airport layout plan?
I have experience with developing a sufficient range of alternatives to consider impacts, but not specifically for a master plan for airports.
Your experience would have been in the context of something like a habitat conservation plan?
habitat conservation plans, and other NEPA documents covering a range of activities.
Right. Are you familiar with the FAA's review authority for projects on airport property?
Yes.
What's your familiarity with that?
My familiarity with that is the Olympia Air Show and the Section 7 consultations that have been done over the years because of the federal action of FAA approval.
Right. Fair enough. And how about any other development projects specifically? Construction of buildings, runways, taxiways?
Yes, my understanding is that various projects that are addressed by the airport master plan later will require additional approvals.
Related to those questions, are you familiar with the relevance of the FAA's approval and review authority on the scope of what needs to be reviewed under the State Environmental Policy Act?
I'm familiar with what needs to be reviewed under the State Environmental Policy Act, but I am not a legal expert on SEPA. I've merely reviewed many SEPA documents and have prepared combined SEPA-NEPA EISs.
I'd like to turn to the Endangered Species Act, which is maybe more up your alley, and start with some basic background of the ESA. Is it fair to say that, generally speaking, the Endangered Species Act prohibits the take of species that are listed under the Act?
It prohibits it, but under Section 9, it is often difficult to make a connection, and at times enforcement is lacking. Yeah.
Assuming that a perfect world, if the ESA could be carried out as it was intended, it would prohibit take of listed species then. Is that fair?
It would prohibit take, but not necessarily adverse effects, because you can have adverse effects that do not rise to the level of take.
And the term take is broadly defined as a term of art under the Act. Is that correct?
It is defined under the Act, yes.
And that definition is the type of thing that you testified to yesterday, things like harassment, harm, killing of species.
Capture, collect, trap, wound, yes, or attempt to do so.
Right. And the purpose of the ESA is to minimize and mitigate against those impacts of take on protected species.
The purpose of the ESA in Section 2 is to conserve the species. The purpose of an HCP, if that is your question, is to provide an opportunity for the non-federal activities to move forward and give applicants an opportunity to minimize and mitigate for those impacts.
And the HCP achieves that through a permitting system under an incidental take permit. Is that accurate?
There needs to be a finding when the incidental take permit is issued that if the HCP is properly implemented, that we believe that it will minimize and mitigate to the maximum extent practical. There are often changes in circumstances. A classic one is the Coachella lizard, fringe-toed lizard, where the sand dunes were believed to contribute equally to the dunes, but then it was determined that the one that was being impacted had 95% of the sand coming from it. So there are changed circumstances that in the future, they don't always end up working the way they're supposed to, but they're a very valuable tool. And although they're voluntary, the service is usually happy when people choose to pursue those.
And you mentioned that there are specific findings that the Fish and Wildlife Service must make before issuing an incidental take permit?
Yes.
And I want to review those with you quickly here. Are those under Section 10 of the Endangered Species Act?
They are. Both the components of an HCP and the issuance criteria.
Mr. Examiner, I object to, witnesses are not meant to testify about provide legal opinions. this is an expert witness on wildlife impacts. The entire line of questioning so far has been about the law. And if we have legal issues, we can address those in closing briefs. I don't know if we need to hear Mr. Vogel's interpretation of the Endangered Species Act or FAA authority. These are all legal issues that the port has raised.
But Ms. Newman didn't have a problem when Mr. Vogel was reading through an advisory circular, which is a legal issue. I think this is pretty similar. It's also relevant background to what is addressed in a habitat conservation plan and how that habitat conservation plan, if passed, would mitigate potential impacts from development on the airport property.
Well, with all due respect to the witness, and I think he said this, I don't think he's qualified to give a legal opinion about how to apply the federal statutes or state to this and the procedure. However, I think he can be asked about his familiarity with those rules and whether he has, I'm not sure this is where Mr. Pierce-Wright's going with this, and any experience with it and how he understands they are to be applied. I think that's legitimate. So I forget the question. If I don't think he's being, if he's being asked to give his opinion on, from a legal standpoint on how they are to be interpreted, I don't think that's testimony I'm going to rely on, with all due respect to the witness. But if he's asked his familiarity with it and have they affected the opinions that he provided yesterday and this morning, I think that's legitimate.
Fair enough. And I'm not going to ask him.
Does that muddy everything or clarify it?
No, I think it's helpful. I'm not going to ask him to interpret Section 10 of the ESA, and maybe we can bolster his background a little bit more in this area. Mr. Vogel, how many habitat conservation plans would you say you've worked on in your career?
Wow, I've never added them up.
Quite a few.
Yeah, many.
And those
I
were
used to instruct for the National Conservation Training Center in the class HCPs.
And the purpose for entering into a habitat conservation plan is ultimately to receive an incidental take permit. Is that fair?
That is correct.
And so what you're doing in the context of your work or your instruction on preparing an HCP or receiving an incidental take permit is meeting the criteria under the Endangered Species Act identified in Section 10. So just to reset us where we were, I was asking about your prior history with habitat conservation plans and incidental take permits. And I believe my question was in the context of your preparation and your teaching about habitat conservation plans and incidental take permits. Do you have practice meeting the requirements under Section 10 of the Endangered Species Act for the findings that must be made before a permit can be issued?
Yes.
Okay. I'd like to share my screen. Please let me know if you can see that.
Yes, I see that. Yes, it jumped down on my screen, but
Can you see the top that it says 16 U.S. Code 1539?
yes.
Are you familiar with that section of the U.S. Code?
Yes.
What is it?
It is the authority for incidental take permits.
And I'll drop down to section A2. You can see here it says no permit may be issued by the secretary authorizing any taking referred to in paragraph 1B unless the applicant therefore submits to secretary a conservation plan.
Yes.
Are you familiar with that section?
Yes, I often refer to it as ISAM. It's my little trick to remember. It's impact, steps, alternatives, and measures.
And the plan, it mentions at the top of the preamble a conservation plan. Is that a habitat conservation plan?
It is.
And the plan must identify the ISAM factors you just mentioned. The first one is impact. Are those the types of impacts you testified to yesterday?
Yes, those would be the impacts. In this case, though, it's specifically referring to the impacts of the taking. There can be other impacts as well that probably should be addressed, but the statute doesn't specifically say that.
Okay. And section 2A, 2I says steps the applicant will take to minimize and mitigate impacts.
Yep.
And what's the purpose of that required finding?
That's not a finding. That is a component of the HCP. It's to identify the steps that we will later assess if they're adequate or not.
And what types of steps would those be?
Oh, it might include, depends on the type of activity, but for more sustainable activities, it might be the manner in which things are done, such as in forestry, it might be how long the rotation age is, buffers on streams. In the world of development, where habitat is removed, it often involves the identification of additional habitat elsewhere. So it just depends.
Are you familiar with what the HCP in this case for the Bush Prairie Habitat Conservation Plan, what steps are taken to minimize and mitigate impacts?
No, I've looked through that document. It's 2.5 years old, which kind of made me wonder why it was being delayed. But I suspect perhaps it's because there wasn't sufficient detail to move forward at a normal pace. It would not, in my opinion, it would not have met the issuance criteria as written.
And so it needs to be revised at some level. I'm not asking you about specifics, to meet the criteria to minimize and mitigate impacts.
Yes, and I suspect that's probably what's going on.
Okay. And so if it is ever approved, then it will need to meet, there will need to have been a determination that it meets that requirement.
Yes, there will be a statement of findings produced that addresses the 4 ISAM components, the following 6 components of that I would refer to them as issuance criteria, and then it also addresses any disqualifying factors to demonstrate that there are none.
Okay, and then I'm going to scroll down to sub B. Says if the secretary finds, after opportunity for public comment with respect to a permit application and the related conservation plan, that and can you explain what these findings are stating?
Yes, these issuance criteria, the taking will be incidental, which is a requirement that the actions that are taking the species are otherwise lawful, and it is not the intended purpose of those actions to take the species, merely sort of a side product, if you will. You want me to go through all of them?
No, I think that's good enough. Thank you. And so again, once those findings are made, an incidental take permit will be issued and the covered activities can move forward. Is that generally the order of operations?
Yeah, as compared to some of the other tools under Section 10, if the findings are made on those issuance criteria, the statute actually says that the Fish and Wildlife Service shall issue the permit, whereas other tools, it says that we may.
Right, and can you talk, go ahead.
I apologize. It sticks in my mind because I've been retired less than a year. It's not we anymore.
Fair enough. And so to receive an incidental take permit, the constituent habitat conservation plan can take different forms. Is that accurate in terms of, and specifically I'm thinking of either the specific, property specific, or a more programmatic conservation plan?
To some degree, most HCPs are somewhat programmatic. They can take different forms. It is the applicant's choice as to what geographic area is covered, what actions are covered, what species are covered, and they can, if they don't like one method of mitigating, they can choose another, as long as the issuance criteria are met.
And your understanding is that the City of Tumwater and Port of Olympia are attempting to prepare a programmatic habitat conservation plan. Is that right?
That is my understanding, yes.
And one of the required criteria for passing that plan is to mitigate and minimize the impacts of any development covered by the plan.
Minimize and mitigate to the maximum extent practicable, yes.
Right. And you agree that the proposed HCP coverage area, the Bush Prairie HCP, would include the airport property?
Yes, it would.
And
to clarify, the HCP covers a broader area for purposes of mitigation, et cetera, but for purposes of receiving coverage for take, the airport is inside that as well.
And the proposed HCP covers the species you talked about yesterday. Is that right?
That is correct. Most of the four focal species that we focused on. I also mentioned some of the other impacts that might occur for connectivity, et cetera. But for the lark, the sparrow, the gopher, and the frog, yes. That is the proposal at this point, or was the proposal 2.5 years ago.
Right, and the HCP acknowledges that development at the airport would have impacts to those species.
Yes, the draft HCP does.
And once that HCP receives, is developed into a final form, is it true that it must be reviewed under the National Environmental Policy Act?
That is correct.
And also under the State Environmental Policy Act?
That's state law that I'm not going to testify about. But yes, it will require a NEPA document. It also requires Section 7 consultation, because the act of issuing the permit is considered a federal action.
And you agree that the port has made development at the airport contingent on compliance with the Endangered Species Act?
I believe we read something to that effect yesterday. And now compliance can be, different things, right? As I mentioned, there can be adverse effects without take. You're not out of compliance until you're proven to be out of compliance. So it's a little wishy-washy, but yes, the language we read yesterday was relatively clear.
Okay. I want to touch back on some of the testimony you gave yesterday. You testified to a number of potential impacts you saw resulting from development of airport property, which included new impervious surface, allowing additional development, and moving of fences. Are those activities that would be covered by the HCP?
I would presume so, but again, we're looking at a 2.5-year-old draft for which the HCP itself is the Port of Olympia's. It's the City of Tumwater and Port of Olympia's, but I'm presuming the Port of Olympia is making the decisions about what to include and how to include it.
Do you have any basis for that assumption?
The HCP is the applicant's document. The service does not dictate what goes into an HCP. It merely evaluates whether it meets the issuance criteria and the mandatory elements.
Right. I guess I was wondering, but as between the City of Tumwater and Port of Olympia.
My assumption was that the port is the primary administrator for the airport.
Your testimony yesterday, you said that moving airport taxiways would result in moving fences at the airport. Do you recall that?
I said it could.
Do you have any basis for that conclusion?
I would assume that the fences would be moved to allow the other aspects that were on the map to avail themselves of their full footprint.
Did you see anything about moving fences identified in the master plan update itself?
I did not. There were other details I did not see either.
I don't have any further questions. Thank you.
Thank you.
Ms. Newman?
Thank you. Mr. Vogel, can you describe the HCP as a broad review for what coverage? What is it overall reviewing?
The HCP reviews, and I think I'm not sure exactly what you're getting at, but I'm going to take a shot. The HCP focuses on the taking of the listed species, not just the adverse effects, and the actions that are causing that taking. And then it also focuses on how that taking is going to be minimized and mitigated.
Is it just limited to the airport property, or is it broader than that?
The Bush Prairie HCP is broader than that. It is apparently being worked on by the City of Tumwater and the Port of Olympia together.
What's the whole geographic area that it covers? Generally, you don't have to be perfect.
The City of Tumwater I do not know the exact limits of the City of Tumwater, but I would say it looks like it's the City of Tumwater for the impact area, and then portions of Thurston County to the south that appear to be included for potential mitigation areas.
Okay, and so would it surprise you if it was the urban growth boundary for the City of Tumwater?
It would not surprise me.
Okay. So the HCP is not an analysis of impacts caused to wildlife specifically by the adoption of the MPU, the master plan update, correct?
Yeah, not at all.
And it does not contain an analysis of the environmental impacts of all the different alternatives that are set forth in Chapter 4 of the MPU?
Can you repeat that question, please?
Does the HCP contain an analysis of environmental impacts that would be caused by the different alternatives that the port set forth for a development plan for the next 20 years in their master plan update?
Well,
so
excuse me, let me interrupt. I'm sorry, I'm not objecting, but when you say the HCP, Ms. Newman, are you saying, is that a reference to the draft or to what he assumes will be in the final one, or in general what an HCP should do?
The current draft.
I
guess all three of the above, that the draft, any future version.
Yeah,
would it contain an analysis of the environmental impacts of the alternatives? Would an HCP, the Bush Prairie HCP I can do all of them. The draft Bush Prairie HCP that is an exhibit in the record that we've been talking about all morning, does that contain an analysis of the environmental impacts of the different the different alternatives for a development plan for the next 20 years that the port has presented in its master plan unit update?
May I respond, Mr. Hearing Examiner?
You may respond as best you can.
Okay, so the draft, I could not tell that it covers all of those things, and the intent of the HCP is to cover the effects of the taking. So it is likely that the HCP would not cover all of the effects of the actions at the airport. The alternatives could be crafted to be the same, but the HCP would not require the assessment of effects beyond the effects of the taking. And to that, it would only focus on the effects to those species.
Okay, and the SEPA, is it your understanding that the SEPA review is meant to inform the port's decision of whether to actually adopt the preferred alternative that will, engage in the action that will cause the take in the first place?
Objection. So Mr. Vogel's already testified that he's not an expert on SEPA. Ms. Newman also previously objected to Mr. Vogel testifying about legal issues, and this is a question about asking for a legal conclusion.
Ms. Newman, with respect, I'm going to sustain the objection. I think that's it's going to be my decision to determine whether SEPA covers that. I'm not sure, with all respect to the witness, that I would rely on his opinion about whether it covers it. I think that does kind of get into the legal interpretation area.
Okay. Mr. Vogel, you said the incidental take permit only addresses the impacts of the actual killing and harming of these species. You testified about a lot of other impacts during your direct testimony. Can you just elaborate a little bit on the categories of impacts that are not addressed by the incidental take permit?
Yes, there are portions of the airport that if you went out and surveyed, you would find that they are not currently occupied, or that you were unable to demonstrate that they are occupied. And the port could develop those lands without any threat of prosecution under Section 9 of the ESA. That even if those habitats were vacant, would still be an adverse effect to the species, but it would not rise to the level of take. And eventually, losing unoccupied habitat often leads to the loss of adjacent or intervening pieces of habitat, and then they become available for development as well.
Okay. And you mentioned during your direct testimony that there were harassment categories, habitat removal, indirect effects, facilitated effects, and cumulative effects. Are those different categories of impacts covered by the incidental take permit?
Well, there's no incidental take permit yet, and
Okay.
it was not clear that all of those categories were adequately addressed in the draft. But again, in fairness, that draft we're looking at was a 2.5-year-old document. I am sure that the current draft is probably doing a better job of those. However, facilitated impacts are often the ones that are most neglected, even though our guidance is clear on how to deal with those. I said hour again, I apologize.
Okay, I have no further questions. Thank you.
Mr. Pierce-Wright.
I do have some recross. Thank you for your patience, Mr. Vogel.
Can we make it brief, but go ahead.
It will be brief. You testified in response to questions just now that you thought that there could be portions of the airport not covered by the HCP, or where development could occur without risk of take. Is that a fair summary of what your testimony was? Are you hearing us?
Can you hear me?
Yes.
Yes,
Yeah, we
but
hear
not
you,
previously.
but Mr. Wright just asked you a question.
I'm sorry, if you could repeat that, that would be great. I lost my screen again.
That's all right. So my question was, my understanding of your testimony just now was that there could be development at the airport that would not result in a take because it was not covered or that portion of the airport didn't include any protected species. Is that fair?
I don't know if he's hearing you.
I think he's losing the audio.
Can you hear us, Mr. Vogel?
Yes, can you hear me?
I
Yes.
can. Did you hear my question just now?
No, it cut out again, and now my picture cut out a little bit too, but go ahead. I'm sorry to make you repeat.
That's
We
all
don't
right.
have longer to go, so let him ask the questions and then I have one or
Yeah.
two and then we can free you up.
Okay.
So my question was, it sounded from your testimony just now that you were saying that it is possible that there are portions of the airport property where there are no species, and those portions could be developed without or without coverage under the Habitat Conservation Plan or an incidental take permit.
Yes.
And that's a fact-specific determination based on where species are located. Is that fair?
That would be where the surveys would indicate that those areas were unoccupied. Yes.
I will share my screen. I'll show you the conservation plan, which is Exhibit 54. Are you able to see that?
Yep.
And I'm going to scroll down to PDF page 62, which is page 2-23 of the plan. Have you seen this image before?
Yes.
And is it fair to summarize that this identifies where any species have been identified at the airport?
I'm going to assume it's accurate. For my answer, I would say yes.
And this identifies that there are species over the, are you aware of any portions of the airport property that are not covered by species as identified in this image?
Well, as identified in this image, I know there are pieces that were discussed yesterday, for instance, that were determined to be unoccupied by gophers and were being considered for lease, for instance. That's the example I was trying to provide.
Okay, so that was testimony about areas outside of the airport property. Is that accurate?
I guess what I'm looking at here, though, the Vesper sparrow locations look accurate, but those are old. Street horn lark, I believe, we're more towards the middle. It's hard to see those on here. It's just kind of a red dots. And the Olympia pocket gopher, that is I don't know if that is a map of actual occupied habitat or suitable. That green is covering so much of that area. My judgment would lead me to believe that that is identification of suitable habitat, not necessarily occupied.
Okay, but do you agree that this map is identifying the entirety of the airport property as covered by those species?
I will take your word for the airport boundary. Yes.
Fair enough. No more questions.
Mr. Vogel, if you could, I have, I think, two questions.
Yes, sir.
And you may have testified to this, and it's in my notes, but under non-project actions, under either NEPA or SEPA, have you had familiarity with any, with being involved in them or commenting on any that were that phased the environmental review?
Yes. The Northwest Forest Plan, Olympic National Parks, activities. A number of Section 7s that I've worked on were at the programmatic level. And, you know, my heart goes out to people that have to deal with it. It's not easy, but generally, you know, you do the best job that you can. You make your best projections, and perhaps sometimes you take a reasonable worst case scenario and project those impacts. And people recognize that when you get more specific later on, that those impacts may change because the environment changed or you have more specific information. But generally, by addressing those effects early on as best you can, it allows better decisions, and we get better feedback from the public as well.
And thank you. My second question may be complex. I may not phrase it very well, but the lead in is that it's going to be my decision on whether the appeal about the MDNS is sustainable or meets its burden of proof. And phasing has been raised in some of the briefing. And I'm not asking for you to give me a legal opinion I have to rely on and how I come to decision, but within the ambit of your testimony and knowledge, do you believe that possible future impacts on the species you were talking about could or should be handled in a phased review rather than either at this initial stage or at some other later stage? I don't know if I phrased that very well. Given also that that a final HCP or revised one hasn't been issued yet.
Oh, we lost him again.
Probably because of my question.
Mr. Examiner, I am hesitant to
You're going to object to my question.
object to a question, but that is a very important issue to us on a legal level. And I just want to mention that as an aside, that I'm not certain that Mr. Vogel is that familiar with SEPA to the extent that he could provide valuable information with respect to phased review under SEPA. But you can ask the question. It's a very, very important issue to us.
You know what, Mr. Vogel, there's the lawyer for the appellant has questioned the legitimacy of my question, so I'm not sure I should have you answer it. But
I'm back, and I heard portions of the question. And again, I'm so sorry. I usually don't even have coffee here, but I spilled coffee just before we started. So
I did that a few
right
weeks ago.
across the keyboard too.
You know, I'll withdraw my question because it's going to be my decision, and I understand your testimony. So let me withdraw the question. I think we're finished. Not finished with you. I think your testimony is finished, Mr. Vogel, and there's no follow-up from the attorneys, I assume, for more questions. We have had enough questions. So I think we can release you now. Thank you very much for appearing yesterday and today.
All right. Thank you very much.
Thank you. Thank you, Ms. Newman.
Thank you
for helping me form my thinking. Who do you have next? And do you want to take a break before you call the next person?
Mr. Examiner, this is Zach Griefen for the appellants. Our next witness will be Rhonda Larson-Kramer. Her testimony is going to take some time. This might be a good time for a mid-morning break.
Mr. Pierce-Wright, Mr. Anaker, are you okay with a short break?
A break is fine. Do we want to work on dates before we do that?
Oh, let's do that. Yeah.
It's my guy.
Let me, I've got to pull my calendar on my phone. Ms. Newman, which is the witness that could not appear this week? Who is
his name? Is James Matthew. He is an expert hydrogeologist.
Right, I have his resume. And when would he be available?
He gave me 1, 2, 3, 4, 5 dates. So I'll recite them. Friday, July 25th, Thursday, July 31st, Friday, August 1st, Monday, August 4th, and Tuesday, August 5th. And I'm available all of those days.
I am.
Counsel for the port, you have your calendars in front of you now. It looks like I'm available all of those dates.
So we are available, all of them, except only, there's a gap in the middle of the 31st that I'm not available.
Morning or afternoon gap.
So I'm not available between 10:30 and 1:30.
So given that, you'd probably rather not do it on that day anyway.
Right.
At least I wouldn't.
If we could choose the first, that might be the preference, if that's an option.
Yeah.
Well, I'll tell you, I don't know how we're going to. There's a separate issue here, which is for other reasons, I would rather free up this Friday, but I don't know what the council think of that. If we set one or two dates off the dates you gave us and not have a hearing Friday, we should be able to get done, I think. I don't know if anyone objects to doing that.
No
Maybe I
objection.
missed the first part of your,
Well, I'm trying to free up this Friday.
Sure.
For other reasons, but we can continue the hearing Friday if the parties really want to do that. But if I set one of these other dates, I'm thinking I would set one or two of them, and the witnesses that might have gone on Friday could also then be on the date that Mr. Matthew testifies. I'm thinking that the port.
I see.
I'm thinking, Ms. Newman, that you're not going to be done with your witnesses other than Mr. Matthew until sometime tomorrow, correct? Or
I can
Mr.
weigh in on that if you like.
Yeah,
Yeah,
maybe
Mr.
Zach.
Griefen, do you go? Yeah, give
we
me an
have-
idea.
We have two more witnesses, Rhonda
Three.
Larson Kramer, three, including James Matthew.
No, Mr. Rob Reeson.
Oh, and we have Rob Rosine today too. So we have three more witnesses today. I'm cautiously optimistic that we could get through them today. I think we'll be done with Ms. Larson Kramer by lunchtime, and then that would leave two for the afternoon. If we did stray into tomorrow, it would be done by tomorrow morning. I'm not sure how long the port's witnesses will take.
And port lawyers, you have Mr. Paolini and Mr. Gilbertson, I think, or
They're going to be the primary ones. It seems like we will likely finish before Friday with all of them.
oh. Well, in that case, let's set one of these dates. I'd rather, if we could, Ms. Newman, do the 29th, because this is stretched out and then you're going to have closing arguments in writing and then a decision. And I know the 31st is out, and I know that August 1 and July 29 are obviously close to each other, but if we could do it on the 29th.
It's actually the 25th, July 25th is
25th.
the
I'm
date.
sorry. I thought it was
That's no problem.
I misheard you. No, it is the 25th. And so what if we set the 25th, strike this Friday and set the 25th for Mr. Matthew? And then if there are other, I appreciate the the port witnesses may be finished this week, but if they're not, we can have one or two of them on that day.
Maybe with the caveat that I don't know that they're available.
Right,
Okay.
I understand that. I'm sorry, I understand that.
That's fine with.
I mean, I may
us.
be going a little far here. I don't want to tell people what to do. I've read, I'm not saying I'm going to rule, but the port documents are fairly comprehensive on what the port looked at for the update, and but it will be helpful for me to hear your witnesses on how they concluded that that the MDNS correctly addressed everything at the appropriate time and that the checklist was complete. So I do want to hear their testimony. So let's do this. Let's strike this Friday, and then schedule it for July 25th.
Okay.
And then we can discuss later, maybe even this week, what schedule you want for written closing arguments. I have to tell you, because I've been in your positions before, that the idea of closing argument trying to cover all the testimony exhibits is somewhat daunting. You're going to have a lot of work. So later, I'd like to know how much time you think you're going to need to draft those and edit them and get them out. But we don't have to decide that now. So let's move the date, and I've got 10:30 right now. Is that correct? Or 10:32?
Yeah.
Let's convene at 10:45 again, if that works.
Okay, thank you.
Yes, thank you.
Thank you all for being.
Thank you,
thoughtful.
Mr. Examiner.
Thank you.
Yeah, thank you. I've dealt with difficult lawyers. You're not in that group. Thank you. I'm back. Are we ready to go?
Yes, Mr. Examiner.
Okay, who do we have next, Mr. Griefen?
Rhonda Larson Kramer. Would you like to swear her in?
Yes. Ms. Kramer, could you raise your right hand, please? Do you affirm that you will tell the truth and nothing but the truth in this matter?
Ms. Kramer,
your
you're
audio's
muted.
off. Your audio's off.
I do.
Okay. I saw your lips move. I assume that's what you were saying. Go ahead.
Thank you. And Mr. Examiner, before we start the direct examination of Ms. Kramer, I have a preliminary point. We submitted an exhibit list and exhibits. In some of those exhibits, there's yellow highlighting added to the original documents. Rhonda Larson Kramer put in that highlighting. The parties have been working with these exhibits for some time, but we can either keep those exhibits as is, or we'd be happy to replace them with clean copies without the highlighting, whichever the examiner prefers.
When I read those, unless they were, if they're coming from, for example, your witness now and they're not in the original document, they're not going to sway whatever the witness highlighted is not going to sway me. So I can, I don't need to have a clean copy submitted unless the port objects to the ones that have her highlights on them.
If you can ignore the highlighting, that's fine with me.
Yeah, I do my own highlighting. Sometimes use a different color. They're in like a pale yellow, so I'm going to ignore them as part of the original document.
Excellent. Thank you, Mr. Examiner. Okay, Ms. Larson Kramer, please state and spell your name for the record.
Rhonda Larson Kramer, RONDA LARSON KRAMER.
And where do you live?
1814 East Side Street, Southeast in Olympia.
And how long have you lived there?
Since 2017, but I did grow up in Olympia and then I moved away for college and came back in 2003.
And where is your home in relation to the Olympia airport?
It's 8 miles northeast of the airport.
Did you submit a declaration in the brief to accompany briefing in this proceeding?
Yes.
Can you briefly describe your professional and educational background?
I have a master's of urban planning, a law degree, and a master's of tax laws, LLM, all from the University of Washington. I was a land use and environmental law clerk for a land use hearing examiner's office for 1 year during law school. And I presently practice estate planning and elder law.
Thank you. I'd like to get a little housekeeping out of the way before we dive into your testimony. Did you prepare some of the exhibits in this case?
Yes, exhibits 7 and 8 are 2 newspaper articles I'd like to make a correction on, if that's okay.
Please go ahead and do so.
These are newspaper articles from January 11, 1994, and they have my markups. And my markups mistakenly state that the runway was extended by 40%. The correct amount is 10%. It went from 5,000 feet to 5,500 feet. And you can cross-reference the before and after aerial maps, which I created from Google Earth. Those are exhibits 20 and 21. And you can read the airport manager's statements in the newspaper article in exhibit 61, where he says in 2000 that the runway is 5,000 feet. And then compare that to exhibit 22, which is the Washington State Department of Transportation's 2018 airport profile that says the runway is 5,500 feet.
Thank you very much.
Just for the record, I'm objecting to the introduction of these exhibits.
Right.
I'm fine just reserving that objection until they can lay some foundation for why they're relevant.
Well, let's do that. I tend to in online reporting documents or newspaper documents, I don't have a clear, bright line in my mind about whether some should be admitted or not. I think it depends on how old they are and if they're quotations. If they're being admitted for me to rely on quotations from people in the article. I was involved in a case in the authority. The old authority was you need to have the author of the article confirm. I don't know if there's a Washington State case on this, that he or she interviewed the person or heard the doctor and then related the quotation. So I don't rely on, I'm making a mistake of thinking out loud here, actually. I wouldn't rely on statements made in those articles without some verification by the author of the article. If the witness is trying to make points based on her understanding of what the article said, and then did some data changes or mapping changes based on the articles, I think she can testify on that. So I'll let her testify. I'm not going to admit them yet, but I'll let her testify about them if that's what you want, Mr. Griefen. And the court has a pending objection on the relevance, I guess.
But and I guess my
can I
point
respond
about
to
relevance.
Just wait, Mr. Pierce, right, go ahead.
My point about relevance too is wondering why we're talking about actions taken in 1994. So I suppose they can make the case for why actions 30 years ago are relevant, but it's not on its face apparent to me.
I can respond if you like, Mr. Examiner.
Well, go ahead. I mean, I think it's a valid point. I'm not saying I totally agree with it, but go ahead and respond.
The testimony that Ms. Larson-Kramer just gave was only to correct, as we just mentioned, she made some markups to some exhibits in the record. And in exhibits 7 and 8, there was a markup that was incorrect. And she just corrected it and then explained how she determined that it needed to be corrected. As to exhibits from prior years, I'd point out that the port itself is seeking admission or has been admitted, the 2013 MPU update. The development of the airport has a long history. There's been many statements over the years by port officials about what they intend to do and do not intend to do. And sometimes that has corresponded to what they actually did, and sometimes it did not. In this case, the port is saying that no development is proposed in the master plan update. And there'll be testimony later that demonstrates they've said essentially that exact same thing in the past, and then gone ahead and developed the airport in that way. So it goes to the credibility of the port and its witnesses, where they're now saying we're not proposing any development. But in the past, they said no development is proposed, and then went ahead and developed it.
If I could
Well-
respond to that.
Yeah, go ahead.
So the 2013 master plan update is the one currently in effect. I'm not sure there's any reasonable debate that that's not relevant to what's happening now. What Mr. Griefen has just explained is in effect impeachment, and he's trying to use evidence through his own witness to impeach port witness testimony based on statements made by other people. I'm not aware of any legal basis for that type of impeachment evidence or grounds to admit it through appellant's own witnesses.
I could respond.
Very briefly.
My understanding is that the rules of evidence that apply in court are relaxed at the hearing examiner level. And my respectful suggestion would be that all exhibits be admitted and then given the weight that the examiner thinks they deserve.
Well, I think you both make very good points. I do distinguish between older documents. When I say older, documents of over a decade or old that are official documents or it's someone signed or published, with newspaper articles or notes people took relating what someone else said. I do distinguish those. And I think the easiest course, especially, is to admit exhibits that a witness has either made or is relying on in the testimony, and to just state, I can give it, I can decide how much weight to give it. That prevents me from, or that eliminates the possibility of me not accepting an exhibit and then having an appealable issue that I should have accepted the exhibit. In this case, Mr. Pierce Wright reserved his right to object. So I'm not going to admit them right now. I'll allow her to testify about them, but I'm not going to admit them. I may admit them, but I'll decide how much weight to give in looking at those exhibits. And Mr. Griefen, I want to give you leeway to make your case, but they are, if they're being used to talk about, to impeach, I guess, port witnesses when they appear, then I suppose they can be used to cross-examine the port witnesses. But let's proceed. I'm not going to admit them right now, but I'll allow some testimony on them.
Thank you. My concern is that we may want to refer to these exhibits in the closing briefs. And if they're not admitted.
I'll clarify that before we get to that point.
Okay. Thank you, Mr. Examiner. Ms. Larson-Kramer, are you familiar with the Port of Olympia's 2021 draft master plan update?
Yes.
And are you familiar with the port's SEPA mitigated determination of non-significance, or MDNS, that's at issue here?
Yes.
And are you familiar with the port's SEPA checklist?
Yes.
Does the ports, I'm going to use the acronym MDNS for Mitigated Determination of Non-Significance. Does the port's SEPA MDNS anywhere state that the port is using phased review under SEPA?
No,
Does the port's SEPA checklist anywhere state that the port is using phased review under SEPA?
no.
We'll come back to the port's SEPA materials in a little while, but I want to turn to the master plan update now. Do you know how the FAA describes the purpose of an airport master plan?
Objection, she lacks foundation to testify to this.
I think she can answer whether she knows how the FAA describes the purpose of an airport master plan.
Well, I'll allow some question on this. I think she can answer her understanding of it. No offense to the witness, I'm not sure how that's going to inform my decision, but I'll allow some limited questioning on that in that line.
Sure. Let me rephrase the question a little bit. Ms. Larson-Kramer, are you familiar with Exhibit 57, that is FAA Advisory Circular 150/570-6B?
Yes.
And are you familiar with how that advisory circular describes the purpose of an airport master plan?
I am.
And how does it describe the purpose of an airport master plan?
I would ask first, before I state that, if people could pull up 57, Exhibit 57.
I have it. Let me interrupt you for a moment. Mr. Examiner, I'm not going to attempt to share PDFs on my screen. I was unable to make that work yesterday, and I'm not going to try it today. The witnesses have their own copies of exhibits. It appears that you have hard copies, and I have my own copies. So I'm hopeful that everybody will be okay with looking at their copies of exhibits without me sharing them on the screen. So Ms. Larson-Kramer, I have Exhibit 57 up on the screen to my left.
All right. And so I would ask people to look at numbered page 1, and this is also PDF page 9 of 152 pages. And on page 1, it states, quote, "An airport master plan is a comprehensive study of an airport and usually describes the short, medium, and long-term development plans to meet future aviation demand." And then on the bottom of that page, it states, quote, "The master plan is the sponsor's strategy for the development of the airport," unquote. And sponsor is Port of Olympia in this case, just for clarification.
I'm sorry, which page are you on in that?
That is numbered page 1 and PDF page 9.
Are you, Ms. Larson-Kramer, are you looking at that page right now?
Let me pull that up. Hold on here.
It's okay. I can represent that. I'm looking at the page, and the top of the page says Part 1, the process of preparing master plan studies, Chapter 1, Introduction, 101, purpose and application.
I'm there now, by the way.
Okay. And what does it say on the following?
I'm sorry, I wasn't done though.
Okay.
So on the next page, at PDF page 10, and also numbered page 2, the FAA states, quote, "The goal of a master plan is to provide the framework needed to guide future airport development that will cost effectively satisfy aviation demand while considering potential environmental and socioeconomic impacts," unquote.
Okay. And how does the port's master plan update itself describe its own purpose, the purpose of the master plan?
So now I will ask that people bring up chapter 1 of the master plan. That's exhibit 1. And to go to page 1-1.
I am there.
All right, so at the bottom of the second paragraph, that states, quote, the overall purpose is to guide the development of an airport over the next 20 years, unquote. And then in the next paragraph, it states, quote, the master plan update culminates in a recommended phased 20-year airport capital improvement program, unquote.
Thank you. And does the master plan update state how it was developed?
According to the port, the master plan update was developed after a lengthy master planning process that included stakeholder input, technical advisory committee meetings, and public comment. And that is according to Exhibit 1 at pages 1-1, 1-2, 4-1, and 4-2.
Thank you. And how is the master plan update organized?
The Olympia Airport Master Plan update is organized into chapters, and these chapters address 1, inventory of existing conditions, facilities, and issues. 2, forecast and future activity. 3, identification of facility requirements and needs. 4, airport development alternatives and recommended plan. 5, airport layout plan. And 6, implementation. And what I just read is set out in Exhibit 1, Master Plan Update, Chapter 1 at pages 1-2, 1-1 and 1-2.
Thank you. We're going to focus on the preferred alternative that was selected by the port and that's described in Chapter 4 in just a moment. But I have a quick question for you regarding Chapter 2 first. In Chapter 2, what does the port say? What does the MPU Chapter 2 say about the port's plan for more hangars?
I'd ask people to bring up Exhibit 1, Chapter 2, and then go to page 2-24, which is PDF page 26.
Okay, I'm there.
In the first paragraph under table 2-19, it states, quote, this methodology assumes that the findings of the HCP will allow for further hangar development at the airport, providing additional room for larger based aircraft such as jets. As hangars are built and business aviation demand increases with the growth of the county and regional population, based jets and turboprops, included in the twin engine category, are forecasted to see somewhat dramatic growth at the airport, unquote.
Thank you. And now let's turn to Chapter 4 of the Master Plan Update. How does Chapter 4 of the Master Plan Update describe its own purpose? That is the purpose of Chapter 4.
I would ask that people bring up Exhibit 1, Chapter 4, and go to page 4-1, which is PDF, page 1.
Okay, I'm there on the first page of Chapter 4 of the MPU.
So this chapter says on the first page in the first sentence that the chapter, quote, provides for the implementation of the facility needs identified within the master plan update, ... culminating in a single preferred alternative, unquote.
Thank you. And what do those alternatives in Chapter 4 reflect?
So I'll ask people to go to the next page, which is page 4-2. The first sentence under section 4.2, airport alternatives, says, quote, the alternatives, to include the preferred alternative, reflect extensive analysis of the facility needs, fiscal abilities, environmental constraints, current use, and forecasted growth of the airport, unquote.
And what sorts of development alternatives are described in the, I'm going to use the acronym MPU sometimes, MPU or master plan update?
The master plan update includes detailed alternatives for taxiways, airport taxiways. It analyzes 3 taxiway alternatives at pages 4-3 to 413. It analyzes 2 runway alternatives at pages 4-15 to 4-18. It analyzes 3 airport development area alternatives at pages 4-19 and to 4-30. And
Thank you.
there's
Oh,
no
go ahead.
analysis of environmental impacts for any of those alternatives other than the preferred alternative.
Do the alternatives in the master plan update discuss where to physically locate different types of development?
Yes, the alternatives analysis of the airport development areas includes consideration of setting aside large areas for 5 different types of development: small general aviation development, corporate general aviation development, commercial development, aviation-related industrial development, and commercial air service development. And that's at Exhibit 1, Chapter 4 at page 4-19.
Thank you. And in this chapter, as an aside, in chapter 4, thankfully, the PDF page numbers also match the numbered page numbers, although 4- is added to them. Is there any review of environmental impacts in chapter 4 of the MPU?
A cursory list of environmental impacts of the proposed airport development follows the alternatives analysis, and that is solely concerned with the preferred alternative, as I mentioned. So this is Exhibit 1, Chapter 4 at page 4-32 to page 4-37, and that's under a section 4.3 titled Environmental Review of Near-Term Projects. So that is solely with the preferred alternative, not the other ones. So they did no analysis of the other alternatives before they chose the preferred alternative. Also, I'll say that immediately above table 4-1, the port states, quote, table 4-1 provides an indication of the likely need for further environmental analysis to determine the exact impacts, if any, that are associated with the proposed improvements, unquote.
Thank you. And Ms. Kramer, is this review of environmental impacts of the preferred alternative intended to satisfy the requirements of the National Environmental Policy Act, or NEPA?
Objection, she lacks foundation
just
to
wait.
make that determination.
And I'll sustain that objection.
I can rephrase the question. Ms. Kramer, according to the master plan update that was prepared by the port, is this review of environmental impacts of the preferred alternative intended to satisfy the requirements of NEPA?
No, the MPU states that this, quote, environmental review is not intended to fulfill requirements of environmental review required by the National Environmental Policy Act, NEPA, or provide a definitive determination of what level of environmental review pursuant to NEPA will be required, unquote. And that quote is at Chapter 4, page 4-32.
Thank you. And is there any indication in Chapter 4 that environmental review is intended to satisfy SEPA?
No,
Same
although
objection
this,
as before.
I'm sorry, you're gonna have to, can you repeat?
Objection, she lacks foundation to make a determination about what does or does not qualify as satisfying SEPA or NEPA.
Right, could you repeat the question? I'm sorry.
I can repeat and rephrase. Ms. Kramer, in the master plan update, is there any indication that what you described as a cursory environmental review is intended to satisfy SEPA?
no, although this section mentions NEPA, it does not mention SEPA.
Thank you. Ms. Kramer, does Chapter 4 of the master plan update adopt a preferred alternative?
Yes, Chapter 4 of the master plan update concludes with the selection and description of the agency's preferred alternative. And that is in Chapter 4 at pages 4-38 to 4-44.
And does the MPU describe the preferred alternative as, important?
Yes, I would ask that people go to the last page of Chapter 4. Give a little time for that.
Okay, I'm there.
All right. So it says in the first sentence that the quote preferred alternative for future development, unquote, is quote essential, unquote, because it ensures, quote, that the airport is carefully and thoughtfully developed through the planning period, unquote. And this is chapter 4, at page 4-44.
And how detailed is the description of the preferred alternative?
The preferred alternative is described with particularity, the size and location of the areas to be set aside for small general aviation development, corporate general aviation development, commercial development, aviation-related industrial development, and commercial air service development are specified both narratively and on a map. And the narrative description is at pages 4-38 through 4-44. And then the map is at page 4-44 in figure 4-9, and it's titled The Preferred Alternative.
Thank you. Is that figure 4-9 preferred alternative on page 4-44 or 4-42?
The map is on page 4-42.
Thank you. Does the preferred alternative specify any future actions regarding taxiways?
Yes, at pages 4-38 through 4-39, it specifies future modifications to airport taxiways, including realignments and removal.
Does the preferred alternative specify any future actions regarding runways?
Yes, at page 4-39, it specifies future modifications to airport runways, and that includes an additional 60-foot wide, 2,000-foot long turf runway.
Does the preferred alternative specify areas to be developed?
Yes, Chapter 4 has a section starting at page 4-39 titled Development Alternatives, and this specifies the category of development under the preferred alternative, the amount of land to be developed in each category, and the location of those development areas.
And what is the first category of development specified in the preferred alternative?
As shown in Exhibit 1, Chapter 4 at page 4-39, the first category of development in the preferred alternative is small general aviation development.
And how much land does the preferred alternative designate for small general aviation development?
As shown in Exhibit 1, Chapter 4 at page 4-39, the preferred alternative designates 96.5 acres for small general aviation development.
And does the preferred alternative specify the location of those 96.5 acres?
Yes, the location is narratively described narratively by reference to runways and taxiways, and that's at Exhibit 1, Chapter 4 at page 4-39. And then it's also described graphically, and that is at page 4-42 in figure 4-9.
Thank you. And what is the second category of development that's specified in the preferred alternative?
Mr. Herrig-Zimmer, I'm fine with them presenting their case as they want. At some point, what we're just doing is reading through the master plan update. I'm not sure that is an effective use of testimony or everyone's time. The rules allow you to limit testimony to provide for an expeditious completion of the hearing. And reading the master plan update through testimony, I'm skeptical it achieves that goal.
Can I respond to the counsel?
Yes, please.
The central issue in our case is that the master plan update provides sufficient information now to assess the probable significant environmental impacts. The port is saying this is no developments proposed, essentially saying, to use a colloquialism, we're just spitballing here, and that stuff will be specified and determined later, and it defers all environmental analysis. The MDNS defers all environmental analysis to some later point. Now, the MDNS does not say that it's engaged, that the port is engaged in phased review under SEPA. And our case, or a central part of our case, is that the preferred alternative is sufficiently detailed and specific to allow for an assessment of environmental impacts now. Ms. Larson-Kramer is going through the preferred alternative in Chapter 4 of the MPU and explaining how detailed and specific it is. And I think it's important for her to do that for us to make our case.
Well, to use a quote we probably all learned in law school, to some extent, or to a large extent, the document speaks for itself. And I understand your argument and pointing me to sections in the document that that can be interpreted in a way that are consistent with the issues that you raised in the appeal. I've let this go on, but let me ask you, how much longer how much more is she going to go from this chapter to other chapters and then read from the document? And then because I can read the document, I don't want to denigrate the witness, but I can read the document myself. And in your briefing materials, you've directed me to these sections that you think are important. So I'm willing to let her continue and decide what weight to give the testimony, but I think the port attorney makes a point that's cogent on this, that I can read the document myself. I can have someone tell me, go to page 4.42, go to this page, and here's what we're going to argue, and not have a witness read them so that she's reading them so that I can, I guess, focus on them. So I'm just wondering how much longer you're going to take with this.
I think the entire examination may be a total of an hour. She's not going to go through every chapter of the MPU.
I'm sorry, an hour longer?
Yes, I mean, as I indicated, her testimony is going to take some time. And it's important to highlight, I mean, the MPU is a very large document, and it's important to highlight just how specific and detailed it is regarding what is intended to be developed under the preferred alternative. And I'd like the opportunity to have Ms. Larson-Kramer testify to that. We will be as concise as we can, but I'd like to highlight for the examiner and for opposing counsel the sections of Chapter 4 that explain the preferred alternative.
Well, Mr. Griefen, I don't want to so is this witness going to go through every section of this document that she or you think I should look at to either suggest that the port did not do required environmental analysis, or that there are impacts discussed that were not covered in the checklist or the MDNS sufficiently, or that she thinks were not appropriately dealt with in this document? Is that what this witness is going to do?
No, this is my examination of this witness is intended to call attention to the specific descriptions of what is intended to be developed on the airport and where that development will occur. And this is very relevant to the arguments that we made in our briefing and will be making in our closing briefing, that the preferred alternative is detailed and specific enough and provides enough information to the agency to assess environmental impacts.
But how is that different from you in your briefing materials or in your argument directing me to those sections and then making your argument about whether those sections were sufficient for SEPA purposes? You're going to direct me to those sections also. Now you're going to ask, now you're having a witness testify and directing me to those sections. So how is that different? I guess it amplifies it.
It amplifies it, and I'm not saying you would say this, but I've had examiners in the past say, if you want me to be thinking about something, you should address it during the hearing and not sandbag me and leave it for briefing. I think we can move through this relatively quickly, but I'd like to give the witness an opportunity to provide her testimony too. And it's certainly relevant testimony.
Well, it's relevant on a scale. I'm not sure where it is on the scale from 1 to 10, but I'll let you continue. But I have to tell you that if what I'm hearing is testimony that simply repeats what you're going to make or have made in legal arguments, that I should look at page 4.39 and a statement in there, then it's redundant, it seems to me. But it's your appeal, it's your burden. So within some limits, I'll allow her to continue. But are you going to have her also do this with other exhibits?
We're largely focused on chapter 4. And we'll get to the other exhibits when we get there, but we're not going to go through every exhibit, certainly. And she's providing more, she's citing to pages that we didn't cite to in our briefing today.
Well, I'm trying to be fair and I don't want to seem impatient, but I think the port makes a good point about this, and I think I've expressed my view. So if you can continue as speedily as you can, it may be of assistance to me. I'm not saying it's not of assistance to point me to certain statements in these documents, but having a witness then read it, and I can read it myself, and then describe how it's relevant does take a lot of time. So I'll let you proceed, but I'd ask you to try to be as efficient as possible in doing this.
Thank you, Mr. Examiner. And I'll note that we scheduled a week for this hearing, and we're going to finish early. But I think we're well within the time that the parties expected to have allotted to them.
Well, we are, and I don't want to seem obstreperous here, but I would have scheduled more time if witnesses were going to be called to read documents that I can read and then comment on them. So, but you go ahead.
Understood. Thank you. We'll move forward, and as expeditiously as possible. I appreciate your comments. Ms. Larson-Kramer, I think we were about to talk about the second category of development, and we'll move through quickly with references. If I cut you off when you're giving a response, please don't be offended if I say, let's move on to the next, okay?
Yeah, and I'm happy to skip to the discussion of the fuel farm expansion, if that helps.
No, let's just quickly go through. So I think we had concluded on the first category of development. What's the second category of development, and how many acres are designated for that?
So the second category is corporate general aviation development, and that is for 48 acres.
And is the location also described narratively and in the text and graphically at figure 4-9?
Yes, that's correct.
And what's the third category of development specified in the preferred alternative?
Commercial development, and that is for 3 acres.
And is that also described both narratively and graphically in figure 4-9?
Yes.
And the fourth category, same questions?
Aviation related industrial development, and that is for 200 acres, 200.5 acres. And that is also specified narratively and graphically at 4-40 and a figure 9.
Figure 4-9?
4-9, thank you.
Thank you. And is there a fifth category, and how much land is set aside for that?
The fifth category is commercial air service development. That's for 54.5 acres. And that is also described on the 4-9 figure and page 4-40.
And seventh category?
That is
sorry, a sixth. I think we were just finished 5. A sixth category?
Yes, the sixth category is agriculture. That is for 25 acres. That's also on the page 4-40 and figure 4-9.
And what is there a seventh category, and
Yes,
what is that?
That's right. There's a seventh category. It is fuel farm expansion. And this is not graphically called out. It is narratively discussed on 4-40. It is on chapter 5, sheet 15. Very hard to see, very small. It's on the Northwest Development Area Plan, which is sheet 15, and it's a white building on the upper left side of the sheet. You would not see it if I hadn't pointed it out to you, I have to say. And then it's also not labeled, but it is also present on figure 4-9, but you would never know where it was. In that graphic, it's to the left of the GA small, the polygon, the red polygon that says GA small 23.8 acres. And it's below and slightly to the left of the, quote, infiltration facility, unquote.
Thank you.
But I wanted to point out, I'm sorry,
okay, go ahead.
Wanted to point out that the narrative description of the fuel farm expansion is not that it's going to be broadened as far as area that it takes up, but rather that it's going to be doubled in capacity. So they are going to double the capacity of the fuel available at the current airport.
Thank you. And you referenced chapter 5, which we'll discuss briefly in a little while, which is all the site plans. But I think you said you can't see that there's no label for the fuel farm on figure 4-9. Is that right?
That's right.
Okay. And let's figure 4-9 is important. It's the overall map in chapter 4. It's at page 42. Let's just look at that quickly. On this map, which way is north?
North is to the right. You would have to rotate the figure clockwise to make north at the top.
Okay. Did the port in its SEPA materials or in the MPU conduct any analysis of probable environmental impacts of developing the areas for the purposes that are shown on this map, or for the categories?
No.
While we're on this figure 4-9, there's been some mention of something called the Swire lease. Can you describe where the Swire lease is on figure 4-9?
Yes, the Swire lease area is more or less coextensive with the gray shaded area near the legend that's labeled airport related industrial, 110.5 acres. That's figure 4-9. And this is on page 4-42 again. So I would ask that you also turn to Exhibit 32, which is titled Swire Lease Image, if you would.
Sure. So I've pulled Exhibit 32 up. Did you prepare this exhibit, Ms. Larson-Kramer?
I did.
And what does Exhibit 32 show?
It shows the approximate area of the Swire lease outlined in red. As you can see, it matches up with the gray shaded area near the legend that is labeled Airport Related Industrial 110.5 acres on figure 4-9 that we were just discussing.
Just noting for the record that we had objected to this exhibit previously as not relevant to this matter.
Right.
Mr. Examiner, we've introduced this Exhibit 32 as an illustrative exhibit only. It's Ms. Larson-Kramer's understanding of the rough outline of the Swire lease area and how it matches up to the area shown in figure 4-9.
So the port has objected. The Swire lease is referred to in whether I'm going to look at it or not. I haven't decided, but it is in a number of the materials submitted by the appellants. And I will accept it, not to show the relevance at this point of the lease, or B, the location, but to use as illustrative for the testimony of this witness. I'll admit it for that limited purpose.
Thank you, Mr. Examiner. And Ms. Larson-Kramer, that Exhibit 32 was an outline of the approximate area of the lease area. Is the actual lease an exhibit in this case?
Yes, it is. And I would ask that people turn to Exhibit 31. That's titled Swire Land Ground Lease, December 12th, 2022.
And Mr. Examiner,
for the
I
record,
understand.
same objection.
Just wait.
We'd, oh, go ahead.
Well, the same objection. Again, I will, this witness is going to testify about it. It's in your appeal documents. Again, I'll admit it for limited purpose. I'm not admitting it to suggest that I'm going to deal with the Swire lease issue, or that, or how relevant it is to my review of the MDNS. But since you argued in your appeal on this, and you've admitted it, you've suggested an exhibit, I'll admit it for that limited purpose. And if this witness wants to talk about it. Now the witness has not been, as far as I know, is not a party to the lease or was involved in drafting the lease, or I'm trying to jump ahead here, and may not know the current status of the lease, but she can offer limited testimony along the lines you want to ask her. But I'll just ask you to be to have it as pertinent and as I don't know, to the point as possible. So go ahead.
Yes, thank you, Mr. Examiner. And I'll note that the lease is only 3 years old, and it's a lease of the port, and it relates to the uses that a company may put airport property. So it's relevant to environmental impacts, and we'd like it admitted for what it says, not just what impression it may have made on a particular lay witness.
Well, I'll use the legal phrase again. The document speaks for itself. So I'm admitting it from limited purposes, but the document's in the admitted, and I can read the document.
Thank you. And okay, I'll move forward. Ms. Kramer, briefly, what does the lease give Swire Land Inc. A right to do?
That lease, which by the way is a signed lease, the signature page is not the last page. The signature page is somewhat in the middle of the document. So this lease, but it is signed and dated and notarized. This lease grants Swire a legal right to use the 95 acres for the purpose of constructing manufacturing, warehouse, distribution, and administrative facilities.
Did the port in its SEPA materials, conduct any analysis of the probable environmental impacts of developing manufacturing, warehouse distribution, and administrative facilities on the Swire lease area?
The port signed the Swire lease without conducting any such environmental review.
Thank you. I believe you testified earlier that Chapter 4 of the MPU does not mention SEPA or the State Environmental Policy Act at all. Is that right?
That's correct.
And how does Chapter 4 conclude?
I'd like you to turn to page 4-44 of Chapter 4. That's Exhibit 1. And this section is titled The Preferred Alternative Conclusion. And it states, quote, identifying the preferred alternative for future development at OLM is an essential step in the development of the master plan update, ensuring that the airport is carefully and thoughtfully developed throughout the planning period, unquote.
Thank you. And what does the next sentence say?
But Mr. Griefen, let me interrupt here a moment. I can read the document. I'm going to let you go a little bit, but and nothing against your witness. I don't need a witness to read documents for me, if that's what we're going to do for the next hour.
I understand, Mr. Examiner.
I've never had that happen. I mean, if she has relevant testimony about whether she thinks the document covers something or not, that's fine. But I'll let her read some of these sentences, but I don't know how many. And I have to admit, I'm maybe getting a little impatient, but I can read. And sometimes I don't read things properly and someone can assist me. But if we're going to be here for another 30 or 40 minutes, having your witness read things that I can read myself, I don't know how that helps your case or helps my decision making.
I understand that you're getting frustrated with this, Mr. Examiner, and I'll skip ahead as much as I can. Again, our case, central point of our case is that there is detailed and specific information in the master plan update sufficient to allow a review of probable significant adverse environmental impacts at the non-project stage.
No, let me interrupt you. I understand that, but you can make those arguments without, I mean, I suppose you could have someone read the entire document to me, but I have the document. So again, I'm trying to be fair here and I'll let you make your case, but I don't know how it's helping making your points by referring them to your briefing materials, giving the page numbers, giving the table references, and then having a witness sit there and read portions of the document that I can read myself. I sound a little impatient, but I'm just wondering what.
I understand. I promise that I will try to shorten this up and move expeditiously through it. But I do think that there is value in quoting and reading an important sentence on a page, as opposed to just saying, is there an important sentence, is there an important discussion on such and such a page?
Well, if you think there's some value that's helping you, you can proceed.
I appreciate that, and of course, part of the value is what will be in any transcript if appeal is taken by any party to the case.
Well, again, I'm prolonging this. I understand that, but let's take the SEPA checklist, for example. That's in the record. And if my decision is appealed, it's in the record. And a court can read it. I don't need a witness reading the checklist to me, or sections of the checklist. And I don't know if you're going to have this witness do that, for example. I just don't understand the point of it.
Thank you. We're not going to have this witness read the SEPA checklist, and we're more than halfway done. And I will try to shorten it up as much as I can.
Okay, proceed.
Would you, if if you would like, we could take a short break. I can confer with my witness, and we can come back after lunch and finish it up. And it may be that I can work with the witness to make some more substantial revisions to make her testimony more concise.
Well, Mr. Pierce-Wright, do you have I sound testy, I suppose. Do you have an opinion on this?
I don't know how much longer we have. I guess if for this witness, my preference would be to end before lunch and then proceed with cross after. But if that, if that's not going to happen in the next 15, 30 minutes, then maybe we just take our break now. That's fine.
Well, Mr. Griefen, let me ask you this. Can you complete your direct in the next 15 to 20 minutes?
No, I don't expect that I can, Mr. Examiner.
Again, I apologize to you, Mr. Griefen, and the witness if I sound testy about this, but I don't. I have some interest in being pointed to those sections that are relevant to your appeal, that you think either that you think substantiate that certain things should have been covered in the MD&S and weren't sufficiently covered. But I don't think, I guess I'm being too frank here, I don't think reading sentences and whole paragraphs of a document I can read and you can refer me to is helpful to me. Now, it might be helpful to you and the witness, and I'll let you proceed. But I just want to be honest with you. I don't. I just think there's another way to do it. But I will. Let's take a break now. It's 11:45, and should we resume at 1:15? Does that work for everyone?
Mr. Hearing Examiner, I have a conference in another matter at 1 o'clock.
Will that be done by 1:30?
Yes, he'll be done by 1:30.
Well, let's reconvene at 1:30 then.
Thank you.
Thank you. And Mr. Examiner, I will work with my witness, and we will endeavor to finish up as quickly as possible after the lunch break.
Well, I apologize if I'm being difficult with you, but I just want to move this along, and I'm trying to. I want your presentation and this witness's testimony to be probative, and I don't want it to go beyond that.
Understood, and it's your hearing, Mr. Examiner.
Okay, well, partly. So, okay, thank you. Let's take a break until 1:30 then. Thank you.
Thank you.
Thank you.
Thank you. Bye.